open government is an important concept to uphold in a democratic society whereby transparency and accountability are practiced in order for the public officials to be accountable to the electorates. Thus, where citizens wish to obtain access to information held by the public authorities, they may be granted the right to do so. This is in line with the Freedom of Information Act, which states that any citizen is given the legal right to access federal agency records or any such documents held by the public authorities. The issue then arises where the classified information concerns matters of national security, defense, or foreign affairs. Such sensitive information cannot be released to the public freely for fear that it may fall into the hands of parties such as hostile governments and terrorist organizations who may potentially have the intention of harming and disrupting the safety of the people. As this is the case, the government will have the authority to withhold documents in the interest of the public as per Section 28 of the Crown Proceedings Act 1947. The power conferred on the government to withhold documents may, however, bring upon an inaccurate decision made by the courts towards the accused due to the lack of evidence. This is clearly a breach on the theory of natural justice. It is then a balancing act for the courts to decide between the two competing public interests whether to compel a public authority to disclose information and risk the safety of the country in question, or to allow the public authorities to withhold documents which may be crucial evidence to the case at hand.
Presumably, the extent to which the government can disclose information in a court of law is great, but there are some restrictions on the disclosure of certain information. One of them is the fact that the Crown has immunity. Under Section 4, Subsection 1 of the Crown Proceedings Act 1947, the Crown may be liable as a private person of full age and capacity. That is only if the activity done by the Crown is commercial in nature. However, if the activity done is sovereign in nature, then the Crown's immunity to disclosure may still apply. Thus, there is no obligation to disclose information. Even though Section 28, Subsection 1 of the Act provides that the government has powers to request the Crown for information or ask them questions related to the case, but Section 28, Subsection 2 provides that the Crown is not obliged to do so. Hence, it seems that the extent of the information disclosure by the government is limited due to the mentioned sections of the Act. In addition, Section 6, Subsection 1 of the Human Rights Act 1998 provides that all public authorities must comply with the rights listed in the European Convention on Human Rights, which is known as the ECHR. By disclosing the necessary information, the government is said to comply with Article 6 of the ECHR, which concerns a right to a fair trial by having a fair and public hearing. So, how does this affect the extent of information disclosure in court? When the information to the proceeding is uncovered, the judges would know what decision to make, as it could be material evidence. Not only the process would be smoother, but a fair and suitable decision would be made. In Mahoney's article, the Strasbourg court stated that the prosecution should disclose all material evidence for or against the defense. Making the evidence unknown to the defense due to the reason of public interest immunity will hinder the act of disclosure. Therefore, the judicial authorities should take an approach that equally balances out the restrictions on the part of the defense. In Roe and Davis and United Kingdom, the prosecution decided that there was not a need to disclose the relevant information to the defense without the consent of the judge. This action was criticized to be not compatible with Article 6 of the ECHR and thus causing the defendants to not have a fair trial. In the later cases of Jasper in United Kingdom and Fitt and United Kingdom, the prosecution were required to apply for a non-disclosure of evidence if needed to do so. Even if the amount of information that should be disclosed can be restricted, it is important to note that the court still retained the need for disclosure.
The public interest immunity doctrine can be defined as an exclusionary rule of evidence. This basically means that it essentially empowers the government to be able to choose to disclose or not to disclose information in court. However, information does need to be disclosed in court if the degree of importance is actually greater than the degree of injury. The areas which qualify for public interest immunity are areas such as national security and also international relations. Before 1947, public interest immunity was actually known as Crown privilege, and what this meant was that the Crown can do no wrong. This actually ensured the immunity of the Crown, and therefore the Crown can actually choose to disclose or not to disclose information in court if it will be injurious to public interest. However, the Crown Proceedings Act 1947 was actually enacted, and this ensured that civil action can be taken against the Crown as against any other legal entity. And also, the courts can actually choose to inquire the Crowns to disclose information if it is important to be used as evidence in court. So, the case of Duncan and Camel Lyot actually illustrates the standing of the courts before 1947, in which the courts could actually choose to disclose or not to disclose information in court based on the grounds of national security. Based on the facts of this case, information can be chose to be withheld from the court if they fell either under the class claim or the contents claim. What the contents claim means is that information can be withheld from the court if the contents of the document would be injurious to public interest. Next, the class claims means that information can be withheld from the court if the information would be disrupting the proper functioning of public service. However, there was a contrasting decision made in the case of Conway and Rimmer, in which the courts actually criticized the decision made in Duncan's case. Lord Pearce had actually criticized that the courts in Duncan's case had not used the balancing test to determine if the public interest used was for the well-being of the ministry or for the fair administration of justice. Now, in line with the progression of public interest immunity, there is a significant case of the Matrix Churchill case, which actually questioned whether the courts had the power to inquire the disclosure of information in court. In this case, the government had actually used public interest immunity to cover the fact that they had supplied arms to Iraq, and this would have actually caused 3 innocent defendants to be convicted wrongly if the judges had chosen against disclosure of information in court. AAS Zuckerman had actually noted that the courts held a bigger responsibility in deciding whether or not the information should be disclosed in court compared to the ministers. Lord Wolfe had actually commented the same thing in the case of R against Chief Constable and West Midlands ex parte Wiley. So, in 1996, the Scott report was actually produced to investigate the Matrix Churchill case. What Scott noted in his report is that the principles used for public interest immunity in criminal proceedings could not be used in the same way as for civil cases. Therefore, the public interest immunity claim, which was made for Matrix Churchill, was actually unjustified. For the first half of the 20th century, it can be clearly seen that the courts had adopted more of an administrative-minded approach in which they easily accepted any minister's claim for public interest immunity. However, there was a significant turning point which occurred in the case of Conway and Rimmer, in which that the courts were emphasized to not easily allow a minister's certificate to be conclusive, but rather that the courts were in just as good as a position as the minister to decide if information should be disclosed in court or not by using a balancing test.
The greatest concern throughout the historical extent to which government are required to disclose information in fact lies in the alternative ground of class claim, which is formally recognized in Duncan and Cameler, where ministers have been routinely claimed class claims as if pronouncing a spell. And because this is due to its broad scope, in which most communication of public bodies will seemingly fit on the basis that it is injurious to the proper functioning of public service, relying on the candor argument, thus leading to a wholesale exclusion of a class of documents, even if it is in the absence of any sensitive or security matters. Notably, this danger subsequently perpetuated along the lines of involvement towards judicial scrutiny, with unequipped and insufficiently independent judges extending blanket immunity to a whole classes of documents just because they are reluctant towards scrutiny and because judges cannot rely on precedent and have to carry out the balancing exercise on a case-by-case basis. Just imagine after the case of Nelson and Longhart, there is now a blanket immunity attaching to all documents obtained in the course of inquiries towards police complaints under Section 49 of the Police Act 1965. before. How then can the injustice to the prisoner who has been wrongfully imprisoned in this case be merely justified just because disclosure might inhibit candor and also cooperation from the police officers? Therefore, it is worth noting that the blanket immunity was eventually removed and the Cass claim abolished following Scott Report 1966. But this issue doesn't solve the whole concern yet, because the guidelines later laid down in that ministers can actually claim public interest immunity if it causes real damage to public interest, in fact lacks clarity, as no definite definition was ever provided. Therefore, it seems that though there is a change or redress towards the widely abused class claim, the subjectivity and the ambiguity of the redress continues to spur concern even until today. Looking into civil proceedings, the main hurdle actually resides within the principle of judicial scrutiny propounded by the case of Conway and Rimmer, where it is decided that where prima facie public interest immunity has been claimed, the courts can only order for disclosure if it is necessary in the interest of justice. But in order to satisfy this, the courts will have to first carry out inspection upon the documents and examine its contents. However, the major hurdle here resides in Lord Fraser's judgment in the case of Air Canada and Secretary of State for Trade, where he actually states that no inspection is allowed to take place if only the applicant can show that his documents will assist his own case. However, this assists a problem in a technical issue where, since in majority of cases the parties seeking disclosure already have no access to the documents, so it is technical that they do not know whether the contents will be beneficial to their case or not. So it is obvious that they cannot foresee the outcome of the case, let alone to say that it will actually prove that the documents sought will actually assist his own case. So this actually imposes a practically impossible and also a very high burden of proof upon the applicant. So this amounts to a bar to inspection and also a reversal of the whole principle. So everything here actually states that the case might likely to fail, and this is the suggestion that is likely to be made. However, this is the similar situation as we can see in the case of Burma Oil and Bank of England, where discovery was actually refused because Burma Oil couldn't establish that disclosure would actually facilitate its case. So the suggestion propounded was that the case would likely to fail because of a technical issue. However, even if later subsequently judicial review is being sought, since mostly areas of public interest immunity are mostly non-justiciable by the courts, it is likely that every judicial review application will also likely to fail. So this amounts to this catch-22 dilemma, which actually propounds that this the whole issue is actually not altered by an open change of policy, but it's actually just a technical ploy in this issue, but it has gravely eroded the principle of judicial scrutiny.
Following the Matrix Churchill case and the Scott Report, it can be seen that public interest immunity actually took an interesting turn in criminal cases. In 1956, Lord Kilmer made a statement on the use of Crown privilege to withhold sensitive information in criminal proceedings. He stated that Crown privilege could not be claimed when medical documents or any other relevant documents are involved in the defense of criminal cases. Later on, in 1981, Attorney General Sir Michael Havas issued a guideline on the disclosure of unused material in criminal cases. However, the 1981 guideline failed to override the common law rule of disclosure of sensitive material. Recently, in November 1990, Lord Justice Mann made a statement in the case of R. and Brixton Prison ex parte Osman that previous courts did not provide any specific judgment if Crown privilege was actually applicable in criminal proceedings. However, he actually considered and decided that its modern incarnation as public interest immunity is applicable in criminal proceedings. Trials in the Crown Court can only proceed if prosecutors fully disclose all relevant information in criminal proceedings. Prosecutors are required to disclose unused materials, which are materials not used in proceedings but may assist the defense in criminal trials. Unused materials was first seen in the case of Brian and Dixon and later extended in the case of Delisa and Caffrey, where the prosecutor is required to call in the witness and make the information available to the defense if it is favorable to do so. Later on, in the case of R and Hennessy, Lord Justice Lawton actually mentioned that prosecutors owe the courts a duty to disclose all relevant information that may assist the defense in criminal cases. Information must be fully disclosed if it is true and it may prove the innocence of the accused. However, if the information is too sensitive, there must be a discussion with the counsel to make some limited form of disclosure in the interest of the defense. In addition, if there is a duty to disclose the information under the law, no further information should be provided since it's against the public interest to do so. Sensitive information, including issues related to national security, or where the disclosure of the informant's identity might let him or his family in danger. Due to the concern regarding public interest immunity, closed material procedure was introduced in the UK. Closed material procedure allows disclosure of any relevant information which is not in the public interest to be considered instead of being excluded by public interest immunity. Closed material procedure was first introduced in the case of Al-Rabi and Security Service, where the Supreme Court had to consider whether the court had the authority to order closed material procedure to order civil claim for damages. It was held that the court could not make such order due to the absence of statutory authority. It was viewed that the provision of closed material procedure was a matter of the Parliament and not the courts. Public interest immunity will have a smaller role if closed material procedure were introduced. Hence, the government does not opt to pursue for this option.
Concerning criminal proceedings today, the prosecution now has a general duty to disclose all information and evidence after the collapse of Matrix Churchill trial, where rule of law and natural justice has been seriously infringed, as prosecution seems to be the judge in his own cause and chose to drop the case rather than disclose information that seems to be necessary to the public knowledge. However, recent data published by Crown Prosecution Service seems to indicate a 40% increase in disclosure failures between the year of 2013 to 2014 and also 2017 to 2018, hence showing that disclosure concern remains a very important and crucial issue in our world today. This is subsequently reflected in the case of R and Allen, which is held in 2018, where a student was wrongly accused of 12 charges, especially the charge of rape, just because of a failure of the prosecution to disclose an evidence which is found to be in the computer data, which will actually turn the whole case around. However, this issue is subsequently addressed by the Justice Committee in its report, saying that the recent proliferation and growth of digital materials such as computer data has indeed proved to cause many police officers many police forces who have not been adequately trained in handling voluminous and large volume of modern evidence to commit more disclosure areas than previous policies. However, this is also incomplementary with the 25% reduction of resources available to the police and crime commissioners, thus limiting them for investigation and further police conduct. Furthermore, Attorney General has also failed to actually update and review the guidelines on disclosure in 5 years since 2003. So this issue has actually led to more cost implications because of late disclosures, no matter whether it is to personal applicants or whether it is to courts. And also, this issue will also lead to further potential miscarriages of justice. Hence, today, many high hopes have been attributed to our newly appointed Attorney General, which is Sir Geoffrey Cox, in actually signing off guidelines in a timely manner and reviewing them responsibly.
The right of access to information held by public authorities is provided under Section 1 of the Freedom of Information Act 2000. However, there are certain limitations on the extent of how much information can be disclosed. For example, Section 44 provides that information can be withheld if it is restricted from other legislations. Also, under Section 21, information accessible through other legislation process are exempted from this act as well. Following the disclosure of Prince Charles' letters to the ministers, there have been suggestions to extend the powers of ministerial veto to renew information by amending the Freedom of Information Act 2000. According to the Press Association, amending the Act would lead to an unconstitutional divine right of ministers, and this would damage democracy and thus leading to occurrence of the ministerial override. In conclusion, extending the powers of ministerial veto will curtail the Act's effectiveness and trim the extent of information disclosure by the government.
In a nutshell, the authority given to the government to withhold documents remains a contentious issue in this day and age. Evidently, following the Scott report, uncertainty as to the exact definition of the word damage in public interest increases complications as to the types of issues that a government is allowed to retain. Additionally, the existence of provisions in statutes which have the ability to defend the Crown from being obliged to disclose is difficult to reconcile with the accused's right to a fair trial. It is therefore necessary for execution of a balancing act, as procedural fairness calls for claims to be decided by an independent and impartial judge as compared to a biased public official. On the subject of the involvement of public interest immunity claims in civil cases, even as early as 1942, the case of Duncan and Cameron Laird have already laid out the principles that the government is allowed to withhold documents if disclosure would result to the detriment to the safety of the people, thus acknowledging the application of public interest immunity. However, during the later years, this decision, which endorsed blanket immunity, was heavily criticized as public interest was deemed to be improperly weighed. In contrast, criminal cases took a differing approach in the sense that initially public interest immunity could not be claimed for. However, as public interest immunity continued to develop over the years, the courts have allowed for claims on public interest immunity. To close this article, a proposal as to a reform on the balancing test should be made, whereby closed material procedure should be introduced. The reason being that the courts, instead of public officials, have the authority to consider material if disclosed to the public would actually cause risk to national security.